State of Murphy versus NYCHA. Counsel?
Good afternoon. My name is Stephen Pecoraro on behalf of the appellant plaintiff. I'd like to reserve 4 minutes, please, for rebuttal.
You may.
So we're here today because the First Department encroached into the jury's role in being the trier of fact.
Counsel, is that the rule you want, that no security measures at all would have prevented this attack?
Absolutely, that no security measures would have prevented the attack?
You're essentially asking them to be an insurer.
No, absolutely not.
So what's the rule you want?
The rule that I want is reasonable security measures should be in place, and a working door lock is not so much to ask, as Mr. Shute pointed out. So
would you accept that there are circumstances where, as a matter of law, the defendant could come in and show that those types of security measures would not have prevented the attack?
there are certain circumstances it would be very tough to imagine. In automobile accident cases, if you're stopped.
What about the perpetrator with the battering ram?
Well, if there were working locks and a perpetrator had a battering ram and was able to go through the locked front doors,
But it's open.
hypothetically, that could break the link. That could break the link, certainly. Here, in this case, when a court encroaches on the jury's role as a trier of fact, oftentimes the court just describes their encroachment as the facts rather than a question of fact. Here, in this case, surprisingly, the appellate division spelled out that they were deciding a question of fact. The last paragraph, the appellate division's last paragraph in its decision states, quote, "It does not take a leap of the imagination to surmise that Cartagena and Brockington would have gained access to the building by following another person in or forcing such a person to let them in." This is their rationale for saying a working door lock wouldn't have made a difference. And they use the word leap of imagination, to surmise. They might as well have said speculation. Speculation.
Why isn't that right, given the video that there's another person who walks into that building, oblivious to what is going on? She
that's
herself, they
correct.
could have followed her in or asked her to hold the door.
That's correct. That happened before the killers
Correct.
came in.
Correct.
This happened 4 o'clock in the morning. So the First Department is saying, well, maybe if somebody else came 5 minutes later or 10 minutes later, it's 4 o'clock in the morning, or an hour later, it wouldn't have made a difference. They're not saying maybe, they're saying it wouldn't have made a difference, ignoring the fact that in those 5 minutes or 50 minutes or 2 hours, Tashana Murphy would have been safe in her apartment. Now,
Well, the video does suggest otherwise, since they kept running back to the door to look through the window to see if these people were getting in the building, right?
that's correct. And as soon as
So
they
they're
found
not
out
really
that they were
running,
coming,
they're not
they
immediately
scattered.
running to an apartment for safety. They're
That's
actually
correct.
hanging around.
But once they saw them coming, they ran for safety. So now, the 2 killers, they didn't have a bag with them. There's no evidence to suggest they had that battering ram or they had burglar's tools. They were just walking in like they owned the world. And if they had to wait 10 minutes or 20 minutes, who's to say Tashana wouldn't have been in her apartment safe and sound behind a locked door? And who's to say that they wouldn't end up finding somebody like Stephen Reynoso or Eric Pierce, who actually were involved in the altercation with them? The First Department, I suppose, they're concluding that if they shot one of those, they would have still kept on going and tried to get to
So your
Shauna Murphy.
argument is
And they wouldn't have been caught, and they
Counsel?
wouldn't have gotten 20
So
years.
your argument
to-
is these were all questions for the jury to have decided?
Absolutely, absolutely.
Was there a factual record about this question of the delay created at summary judgment? How long it would have taken them to get into the building had there been a lock?
No, there isn't. But in this case, we have the video, and we see that they didn't have burglar's tools on them. They didn't have any bags or anything like that, and they weren't able to get through that first door, and that's why they tried what's all the deposition witnesses referred to as a side door. And it's clear that it was broken. It was bouncing in the door frame, and they walked right through. They walked right through. The first department would have you believe if there was a 5 or 10 minute delay and they came in, they would have either not shot any of the other 5 of the group, or if they did shoot them, they'd still try to get to Shauna Murphy, and they wouldn't have been arrested for those murders. They wouldn't have gotten 25 to life, and 25 years later, they would have come out still gunning for Shauna Murphy. It's frankly shocking that the first department highlighted the multiple conclusions of fact that they came to.
Thank you, counsel. Sure.
Good afternoon. May it please the court. Patrick Lawless for the defendant respondent, New York City Housing Authority. The first department properly affirmed the order granting NYCHA's motion for summary judgment based upon the evidence in this case and correctly applying the correct standard. In this case, there was some discussion before about what would be the burden on summary judgment. In this case, NYCHA provided evidence not just that this was a targeted attack, but that minimal security provisions would not have prevented the
Well,
attack.
this one seems a little tougher to describe as a targeted attack. No, could you address that?
It is a targeted attack because this was the result of an earlier altercation. There was a long-standing animosity in this
Do
case.
you have to have a particular individual to be the target, or can it be a group of people who could be the target?
In this case, the target was a group of the specific 6 individuals who were involved in the earlier altercation. The unrefuted testimony shows that the victim in this case was present at the earlier altercation and participated in chasing down Mr. Cartagena. She was known to Mr. Cartagena's girlfriend. This isn't a case where these are all strangers to one another. They were all intimately familiar with one another.
Did the evidence show that the perpetrators knew where to find the victim once they gained access to the building?
There's no evidence of that. Obviously, the perpetrators knew exactly what building to go to.
They know what apartment to go to?
That's not in the record, but obviously they knew what building to go to, and further support that, in this case, the victim was targeted is the video evidence where there's other people congregated outside the building, and there's a young lady walking into the building with her keys. They're completely unconcerned about everything else that's going on, and it's only these specific individuals, including the victim, that keep on running out, looking out the door, and then running back up the stairs. So they know that they're targeted.
Wait, so now it's their issue? They have to appreciate that they're being targeted?
No, it's just further evidence, and it's borne out by by the criminal case against Mr. Cartagena about the testimony in that case. They all said that they knew they were coming after them. They all said that they participated in the earlier altercation and that there was bad blood between them. So that's the evidence.
And they're all interchangeable? Every gang member is interchangeable in that building? So whoever was
It's not
shot and killed?
every single gang member. It's just the specific members that were participating in that earlier altercation. They
So how
didn't-
many of them were there? 7?
No, there were 6. There were
Okay.
6 that were involved in that earlier altercation and participated in that. And as
So
further
I'm
proof.
sorry, to go back to Judge Wilson's question, does that make this a targeted attack since there's, there's a group of candidates, targets of opportunity almost, that they're willing to go after? Does that still fall within what these cases are talking about when they say targeted attack?
Absolutely. My colleague had referenced the Rivera case earlier. In that case, the brother was targeted, and the sister wound up being the victim. She happened to live with him. And in that case, they found that that was still a targeted case. This
What
is
if
even
somebody has a vendetta against the landlord and they want to just hurt someone in the building? Is that a targeted attack?
It depends on the facts and the circumstances and the degree of planning and who they're going to get. But in this case, they knew exactly,
Anyone, but they just have to live in the building.
if it's that broad, I would argue probably not. But in this case, it's not that broad. It's limited to specific individuals that involved in an altercation.
What if 6 people live in the building?
I'm sorry?
What if 6 people live in the building?
If they were involved in an altercation, and if they had a personal animus with the individual against them, I would say yes.
I think I speak for myself, I'm somewhat struggling with the idea of what's the relevance of the targeted attack to this analysis? And as I think I understood counsel in the prior case, if you come forward on a summary judgment motion and put aside what targeted means, but you say, okay, there's a targeted attack, one person in the building, that gets you over your burden to show that minimal security measures wouldn't have prevented this attack, which now goes to the plaintiff to show that the burden now is on the plaintiff to show that they would have made a difference. Do you agree with that?
That you just, I just want to understand what you're asking.
I'm not articulating it very well.
Are you just saying it's just limited to one individual?
No. Forget how many. So as I understand this targeted attack, how it factors into the analysis at a summary judgment motion is the defendant can come in, the burden to get summary judgment, and say this was a targeted attack. That gets you over your burden to show that minimal security measures wouldn't have prevented this. Now that burden shifts to the plaintiff to show the opposite or create an issue of fact as to the opposite. Is that your understanding of how this works?
I would agree with that, but I would also add, in this particular case, whatever the standard is used, NYCHA met it, because it wasn't just that they said that this was a targeted attack and we met our burden, that's it, but they also submitted an affidavit of a security expert, Mr. Cunningham, who reviewed all the evidence, and his area expertise is security management and threat assessment. He reviewed all the evidence, viewed the videotape, and said minimal security provisions would not have prevented this accident. That wasn't refuted in the court below. Plaintiff's counsel now attacks Mr. Cunningham on this appeal, but there's nothing in his opposition papers that even address that. The only citation of Mr. Cunningham in his opposition papers is that Mr. Cunningham agrees with him that the door wasn't working at that time. And in addition to that evidence, NYCHA also, and Mr. Cunningham also established that NYCHA's security measures were reasonable, and there's evidence that the door lock was working on the morning, at least on the morning of September 10th, and that it wasn't working 14, 15 hours later.
I'm still having the following problem, which is that suppose the expert is correct, right? That the minimal security efforts wouldn't have prevented the attack. What difference does targeted make then if we're thinking about this in terms of proximate cause? That is, if it wasn't a targeted attack, your expert presumably would have said exactly the same thing.
Well, I think the significance of the targeted attack has to do with foreseeability.
Right.
Because this court has held that landlords have a duty to provide minimal
I mean,
security
it's just-
provisions
but
or
isn't-
reasonable security
But I
provisions.
take it it's foreseeable that if you have an unlocked door, somebody who's a bad person might go through the unlocked door and hurt somebody,
Well,
right? Just stay there for a second.
Mm-hmm.
Does that seem reasonable?
It's reasonable, but what the First Department and all the decisions going back to Tartar
Yeah.
say is that a premeditated, pre-planned attack that would have overcome security measures is not foreseeable.
Well,
And a
why-
landlord's
wait,
not an
wait, wait,
insurer
wait,
of the.
Why is it less foreseeable that somebody in a gang who is, confronted with somebody from another gang is going to track that person down rather than a stranger walking down the street, seeing an unlocked door and happens to have a gun, decides to go in and hurt somebody? I mean, one of those, it seems almost reversed to me in terms of foreseeability.
I think the foreseeability is you're getting into, again, cases that are, or instances like this that are premeditated, where there's planning. This particular attack took time and planning. It wasn't just a spur-of-the-moment thing. They went to an associate's to get the gun, then they went to the building. There was no cooling off period. They knew exactly what they wanted to do. They were determined, as opposed to just a crime of opportunity. So,
But I guess what I'm trying to say is, it seems to me as a general matter that crimes of opportunity are in some ways less foreseeable than a crime perpetrated by a ex-romantic partner in domestic violence situation.
but then you're but that is, I think, putting the burden on NYCHA and other landlords,
To have a locked door.
not just to have a locked door, but to outwit and outthink any.
No, I mean, if you'd had a locked door, would we have a case here at all?
Well, again, the evidence in this case shows that the door lock was working.
But then
so
you would
this
win.
is- I'm sorry?
Then you would win.
You're
No,
saying
I'm
the
not,
evidence
I'm
shows
not
that the
agreeing,
lock-
but I'm saying that even if no, at the time it wasn't working, but it wouldn't have mattered because the locked door wouldn't have prevented these individuals from entering the
I
building.
understand that. I just am struggling with how that relates to foreseeability.
Well, again, I think it relates to foreseeability in this way, and it's related to duty as well, is that,
No, but I thought, well, that maybe it's the other case. I thought duty was not at issue here.
well, if you adopt, which plaintiff's counsel in this case is requesting, if you adopt the Scurry rationale, then duty is an issue, because then the duty isn't just that to provide minimal security, but it's asking landlords such as NYCHA, which is responsible for almost 300 developments and 400,000 tenants, to outwit and outthink any potential criminal
Is
conspiracy
that
such
what
as this.
providing minimal security is?
It's not saying not to provide minimal security. The minimal security is for foreseeable crime. And pre-planned attacks, I just don't understand how a pre-planned attack is foreseeable. Unless,
How is it not foreseeable that a person seeking to do harm would enter an unlocked door and cause harm to whomever is behind that door?
it's not foreseeable that someone who would be entering the building would be determined to defeat any minimal security measures, no matter what. And again, I go back to the evidence in this case shows that, the unrefuted evidence by the expert shows that minimal security would not have deterred these particular individuals. And on top of that, the evidence also shows that NYCHA did provide minimal security. And the prior case law, and it's cited in our brief, is...
Even the video shows that they did try one door, because there's two doors. Tried one door, that one's locked. And then they went to the one that's unlocked. So if the second one was locked, at a minimum, they're slowed down. I mean,
But-
that's just common sense that way, right?
But the evidence also shows that there were other people outside, and they could have easily gained access, especially given that they were armed. And that's the conclusion that the expert, but on top of that, NYCHA also provided, the point I was trying to make is NYCHA also provided minimal security. So what is being asked of NYCHA is to provide 24-hour
How did NYCHA
security.
provide minimal security if the door was not working?
The door was, the evidence shows that the door was working.
The evidence in the video shows the door was not working.
At
If it was
4 a.m.
working, they wouldn't have been able to open it.
Excuse me, the door was not working at 4 a.m., but it was working when it was checked by NYCHA maintenance personnel. NYCHA's maintenance personnel on weekends, their shift is from 8 a.m. until 1:30.
That sounds like an excellent argument to give to the jury.
But that
An
is also,
excellent argument for why it met the minimal duty, because it was working for a reasonable period of time. Not your fault that it got broken. You couldn't have corrected this broken, malfunctioning lock at a point in time to have prevented the crime. Sounds like a great argument for the
but that is placing an untenable duty on NYCHA then to provide 24-hour security. So what you're saying is, if a door is working during the day, and all NYCHA maintenance personnel go home, and then someone interferes or tampers with that lock at 4 a.m., then NYCHA somehow has to be liable, or they have to prove to
No,
a jury that it's
No, the
not
point was
liable.
that the jury could have considered that.
That's
That's-
a question of fact or summary judgment on breach. That's not on foreseeability. You're now raising a completely, I mean, you
Well,
could do that, you could move.
It's not different. It was in the court below. The Supreme Court found on both bases that there was no notice and that it was a targeted case. The First Department only addressed the targeting issue, but it was still raised in the court below. It was still raised in the appeal brief, and it's referenced in my brief as an alternative grounds for affirmance in this case. Unless the panel has any further questions, I'll rest on my brief. Thank you.
I'd like to just respond to two or three points that my adversary attempted to make. First, with respect to the, quote, unreasonable burden, close quote, that would be put upon the housing authority if the court finds them responsible for the broken lock at the time of this incident. That's not the case. Defense counsel brings up the fact that presumably the lock was checked the day before the murder. What he fails to tell you is that the same standard form the day after the murder says that the lock was properly functioning too. And this is in a number of suspect records that I brought out in my brief. So they're claiming the lock was working fine the day before the incident. Our video shows that it clearly was not working at the time of the murder, but yet the day after, the lock's working fine again.
Counsel, I don't necessarily disagree with anything that you've just said, but isn't your adversary right that we're sort of shifting the argument now, or maybe it was the chief who said this, we're now talking about whether the duty was breached. We could have a factual dispute over whether they provided adequate maintenance in the building and kept everything working appropriately to a reasonable level. And maybe a jury would find that since it was working, I don't know what he said, 14 hours earlier, that was good enough, or maybe they say it wouldn't. But that's distinct from this other rule that seems to have been crafted that an intentional criminal assault in a building breaks the chain of causation because it's not foreseeable as a matter of law, right? Those are two completely different
I
things.
agree with you entirely. The First Department is an aberration with respect to their view of the targeted victim defense. They say once somebody's targeted, we're not responsible. In dicta, Mr. Shute mentioned, they seem to say, no, there can be some circumstances where essentially the landlord gets off the hook.
But basically, there's a blanket
Then they rule
rule.
that here, the landlord gets off the hook.
What about this breach issue, though? The Supreme Court decided as an alternate basis for summary judgment there was no breach?
In terms of the notice issue?
Yeah.
Okay. If you're talking about the trial court, there was oral argument, which is part of the decision, and virtually, if it was 40 pages long, 39 and a half or 39 and 3/4 involved the issue of the targeted victim defense, and the court concluded at the end, since plaintiff was a targeted victim, decedent was a targeted victim, there is no liability. And by the way, we find that there's no notice.
So does
It
the-
really wasn't
And the
discussed.
appellate division never reached that because they went on. So
Absolutely.
what do we do with that issue with the Supreme Court?
Well, my record is clear that there was a breach with respect to the locks. I submitted an affidavit by a locksmith. He examined the door, unlike what's alleged in the respondent's
I think the question
papers.
is, should it go back to the appellate division to
Right.
decide the issue that they had not addressed? The question of the notice.
I think on the record, you can conclude that there is a question of fact as to notice, which can go to the jury.
But you didn't take that issue to the appellate division, the alternative grounds for summary judgment. That wasn't decided directly below, was it?
I believe the language of the appellate division's decision was that they did not have to address the issue of negligence.
But you briefed it to them.
But it was raised, yes. And the record is extensive about the questionable, the reliability of the Housing Authority's records. They claimed the lock was fixed 5 months or 6 months earlier, but it was established that the name, the supposed handyman or electrician was not working the entire month when he supposedly fixed the lock, and other records are missing. Briefly, on the issue of the respondent's expert, his affidavit is so speculative and conclusory that it should be discounted, and I submit that it was responded to by the videos themselves. The videos show that if that lock was working, there would have been a delay, and who knows what would have happened.
Thank you, Counsel.
Thank you.